how can tracing and injunctive relief work in cyber litigation, thinking particularly of the case of cryptoassets?
Yes, this is something which I think lots and lots of interesting developments have been taking place. Certainly in November 19, we had the joint task force, which effectively opined that crypto assets and smart contracts ought to be given the rule of law. We awaited, not for very long, but we waited until 13th of December of 2019 for the courts effectively to tell us that Bitcoin was property. A very, very important case. Those of you who deal with this area ought to be completely familiar with it. AA against persons unknown and others, and that's 2019 EWHC 3665 COM. Judgment delivered on the 13th of December 2019. And that was an application by an English insurer, AA Limited, who had paid a ransom in Bitcoin to persons unknown following a computer hack, which resulted, as often does, in further blackmail and extortion. And so what was significant about that case was that whilst the Joint Task Force had said that crypto assets ought to be classified as property, this was the first real statement from the English courts that we had to confirm that view. Mr. Justice Bryan concluded significantly in that case that crypto assets, and Bitcoin in particular, were a form of property capable of being the subject of a proprietary injunction. And that was obviously a groundbreaking matter, because what that then allowed and allows us as practitioners to do is to trace into crypto assets which have been wrongly misappropriated, stolen, whatever else it may be, and a tracing process through the courts. First of all, injunctive relief is available, and then the subsequent tracing process allowing recompense and those to get crypto assets, which they say they've been wrongly deprived of, returned. Very, very important in a number of senses from a legal case point of view. First and foremost, because, as I say, it recognises crypto assets as property. Second, that it allowed a proprietary injunction in relation to crypto assets. And third, that the judge also anticipated and saw the importance of interlocutory relief and the fact that the application needs to be made urgently, recognising the harm that can be done if assets, particularly crypto assets, are misappropriated. Often in these situations, we may be getting to a stage where interim relief becomes more significant actually than final relief, because in a crypto asset application, what we're concerned with here is speed, often in terms of making sure that it's at least still traceable. One of the things that I've certainly come across in my practice is there's now a number of very, very good and efficient authorities and companies who actually are able to perform the tracing exercises to get Bitcoin returned, or crypto assets, I should say, returned to their rightful owners. And that's an area of expertise which has developed certainly during the period of time that I've been involved in practice with crypto and data. And so it's important now that we recognise that crypto assets are just as capable of being returned, just as capable of being part of the litigation landscape as any other form of property.